Hello and welcome to the David Carrier Show. I'm David Carrier, your family's personal attorney, and you have found the place where we talk about estate planning, elder law, real estate, and business law. So give us a call, why don't you? What could it hurt? 774-2424. That's area code 616-774-2424. If you have a question, comment, or concern about wills, trusts, or probate, if you're wondering how do we beat the high cost of long-term care, if you're if you're wondering to buy, sell, or real estate, it's getting worse out there. Interest rates going up or going down. What's going on with that? The market is up, down, sideways. I don't know. If you're looking to start a business, stop a business, or keep that old business humming like a top, now's the time to give us a shout. 616-774-2424. That's 616-774-2424. If you have a question, comment, or concern, you can also email me, david@davidcarrierlaw.com. And if you email me at david@davidcarrierlaw, see how easy we make it? david@davidcarrierlaw.com. We'll get your question, comment, or concern on the air. If you're, too shy, that would be just fine. You can always go to the website, davidcarrierlaw.com, and that's where you'll find all the information about our upcoming workshops, all the rest of it. Well, we are live and local. It is Easter Sunday, and everybody seems to. It's like so much. It's like estate planning. Okay, everybody's focused on the Easter bunny and eggs, and tend to ignore what's really going on here, right? I mean, think about the promise of Easter Sunday, which is what? Which is somebody's got a talk show, it's all going to be okay, right? Well, that is kind of the promise of Easter, isn't it? Resurrection, redemption, all that good stuff. It's the kind of thing where, you look around, you think, well, this is pretty tough stuff. What's going on? But you always have the promise of redemption. You always have the promise of resurrection. And there's somebody out there who did it before, rose from the dead, for crying out loud. That's pretty good. And you're not dead yet. So nobody's asking you to do that. But, when you look around, you think, geez, could I make things better? Could I have purpose, function, utility, meaning? All those good things, and it's in your power to do it. It's completely in your. It's up to you. It's what you decide to do. And just like Easter gets slurred over with Easter bunnies and colored eggs, and that's all fun. I'm not saying it isn't fun. It's wonderful, and we'll all go out to some ridiculous brunch and eat too much, and then blah blah, because that's what you do on Easter, I guess. And miss the main point. And I feel that's what so many folks are doing with this estate planning, what they call estate planning. Let's do trusts and stuff, and that way when we die, our stuff will go here, there, or whatever. And actually, we're all distracted by, you faithful listeners know, it's all about avoid probate, save taxes, get it to the kids. That's the Easter egg. Okay, that's the distraction. What is it really about? What it's really about, this stuff, first and foremost, if you take the typical tack that people do take, which is avoid probate, save taxes, get it to the kids. Oh, it's all about after I'm dead. Well, you're not dead yet. Okay. I mean, there's plenty of time to worry about that. Once we figured out how to make sure that while you're alive, things work out the way you want them to work out, right? Let's make sure that you're okay first. Let's make sure that your spouse is okay first. Right? Let's make sure that we don't go broke, avoid nursing home poverty. Where have you heard that before? Right? But the idea behind all this, the idea is, well, while you're alive, let's make it happen. Let's do it right. Okay. And even though you may think, oh, well, I haven't done it right yet, or, something like this. Well, what's the best time to plant a tree or an Easter lily, right? Months ago, years ago. When's the second best time? Today. You're not dead yet. There's things you can do. You can refocus. You can figure out what is the important thing. And it's going to be different for folks, right? Some people are going to think one thing, other people are going to think something else. Well, that's okay. Nobody's saying, that. Yeah, I guess here's the point. It's not about what you think is important. Okay. It's like, because everyone's got a different idea, which is fine. Obviously it's fine. God bless America. You can have a different idea about what you think is important. But that doesn't relieve you of the responsibility for figuring it out. Right. I mean, certainly when we're younger, we defer to our parents. What's important? Like for my teenager, like what's important? Getting A's. Yeah, that's important. Now, he also decided it was important to run cross country and spring track and, whatever else he's doing. He's doing a bunch of other stuff. So he decided that was important for him. Okay, fine. But that doesn't, you still got to get the A's. So you defer to other people. What do they think is important? And as you get, as you mellow and age, get old, what was that Woody Allen's line about getting mellow? First I ripen, then I rot. I don't get mellow. As we're ripening and rotting over here, you get to decide what those important things are, right? And what I'm suggesting, which I think is significant, I think it's important. What I am suggesting is take care of you, take care of your spouse, take care of the things that you have assumed responsibility for, right? And the way that estate planning is being done, much like the way that Easter is being done in popular culture, there's some hint of what's really going on. There is some hint. Why the Easter bunny? Why? Because it's new life, right? I mean, and bunnies are famous for bringing forth lots of new life. Same way with the Easter egg, right? What's the significance of the Easter egg? Well, that's where chicks come from. And it's supposed to be, sort of, it's a symbol, right, for new life. Again, that's why we have Easter eggs, and that's why we have the Easter bunny, basically. Look it up. Correct me if I'm wrong. But those things are only hinting at what's really going on, right? Which is the redemption in individuals, redemption in you, and giving you an example of somebody, Jesus Christ, right? Who went the whole 9 yards, right? Into the grave. Took 3 days, came out again, and and started telling people, hey, remember I told you I was going to do this? I did it. Here it is. And now it's up to you to embrace that. And it's a very difficult, and I get that it's a very difficult thing to embrace. I mean, if you remember what happens after Easter Sunday, right? They see depending on which biblical account you go with, there's a guy waiting there, or the women find the tomb empty, and on the road to Emmaus and all that kind of thing. They're better biblical scholars than I am, certainly, who can tell you exactly the different variations in the Easter story. But the point is that these guys didn't get it. I mean, remember the apostles in the upper room, afraid that they were gonna be next, and all the rest. They didn't realize what was going on. And I think that for most of us, it's very difficult, with the day-to-day life that we've got, to realize the opportunity that you have to make things better. And what better day than Easter Sunday, for crying out loud, than to say, hey, I'm going to embrace that new life. I'm going to say, and this is the other thing, by the time we get to Easter Sunday, Jesus has done the hard work, right? I mean, he trudged all around Galilee and again, Nazareth, all those different places, speaking to the crowds and all. It wasn't like he didn't pay his dues. It's not like you didn't pay your dues. You did. So why blow it now? Don't stay in the tomb. Roll back the stone and get out there. Make it happen. Embrace it. Okay, you've done the hard work. All roads lead back to estate planning, I guess. But that's just how I see it. That's don't get distracted. Focus. Eyes on the prize. That's That's what you got to do, and it's all consistent. There's no inconsistency here. So you've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Give us a call, why don't you? 616-774-2424. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. Now's the time to give us a call, 616-774-2424. And don't complain that we gave up the 800 number because y'all have free long distance. Can't kid me. 616-774-2424. That's the number to call if you'd like to get your question, comment, or concern on the air. We are, I know it's Easter, but we are live. As we almost always are, right? Even last week, it was spring break, right? It was still live. And we're the only reason we weren't live on Christmas was because they preempted me with Christmas music. There you go. So I'm here for you. Why aren't you here for me? Anyway, 616-774-2424. That's the number to call. Now, big changes happening. And I've, if you pick up the Sunday paper, you'll this week or last week, I did it. I wrote columns on this topic both last week and this week. And this COVID thing is just about played out. Everybody knows that, I think. Even the president said it's over, right? So if he figured it out, come on. Anyway, what that means as a practical matter is this. Well, you got kids. Let's assume you have kids, or a dog, or a goldfish, or anything that you try to train. You try to impart some of your knowledge and wisdom, right? You wanted them to get the message, right? And and it's hard for people to get the message, right? Not easy for people to get the message. Again, Easter Sunday, what did the apostles do? Did they say, "Oh boy, he's risen"? Oh no! Oh no! They did not do that. They ran away. That's what they did. They hid. And doubting Thomas and all that. Remember? I mean, that's us, right? Anyway, here's the thing. Before COVID, if you received help with long-term care, if you got help with long-term care through Medicaid. And understand, according to the government, 75% of all long-term care is paid by the government, right? That's how it gets paid, and most of that, the vast majority of that money is Medicaid dollars. Okay, so if we're talking long-term care, skilled care, assisted living, at-home care, you're talking taxpayer dollars, your dollars, because you're the taxpayer. The government doesn't have any money except what it took from you or borrowed from your great grandkids. That's where it gets its money. Okay, so it comes back to you anyway. But right now we've got Peter on the line. Hello, Peter. Welcome to the David Carrier Show.
Thank you. Appreciate it.
Thanks for calling.
Good evening, sir.
How can I help?
Just a question as a personal injury. Let me change this question or change the wording here.
Sure.
Medical settlement. Okay, medical settlement. Is that considered a personal injury, or where it's accessible? And is it accessible to a spouse in a divorce?
Well, are you? Well, you stumped a chump on the divorce question, because I'd have to ask. I'd have to use one of my lifelines on that one. Audience. But are we talking about a like medical malpractice kind of claim, or was there a car accident or what?
The national mesh
lawsuit
that's out there and people are getting payments for.
Right.
Is that accessible to consider a personal injury, or is that accessible in a divorce to the spouse?
Peter, I have to admit you stumped the chump on that one. So let me do this at the break. Let me find out if I can get you a quick answer on it. I can get back to you on it. I would think, let me analogize it to something else, and this is not not reliable. Okay. So,
Okay.
analogies work sometimes they don't. But like inheritances, for example, state law says that inheritances don't count, right? So if you inherit money from your parents, it's not supposed to count in a divorce. It always does. You know what I mean? Because divorces don't go to trial. You don't actually operate under the law. It's what you can negotiate, and in the negotiation, if there's a pot of money out there, the pot of money gets divvied up, right? I mean, or at least has some influence. I don't want to say exactly like that, but one of the reasons we're so focused on doing trusts is to increase the likelihood that we can isolate that in a divorce situation for the inheritance, and that works if you do it. But when people just get an inheritance, it just kind of shows up. Now, if there was a dollar amount, an award, and you got a check for $1,000, and the $1,000 goes in the joint checking account, then I would think that that would be part of the marital assets. That's what I would think. I don't know. I don't know. Does that give you any guidance?
As far as inheritance goes, as far as inheritance goes, I'm understanding on how that all works, but I'm specifically looking for in the Michigan law, it says personal injury. So is the national mesh lawsuit considered personal injury, or is that accessible?
Well, wasn't that the whole claim, that there was that it was a malpractice that caused personal injury? The whole idea was that these things...
it's the manufacturers. It's the manufacturers of the mesh, the 5 companies.
Oh, so it's more like a products liability kind of thing.
Yeah, exactly. Yeah. Exactly.
Well, you know what they say about angels, fools rush in where angels fear to tread. I certainly have been a fool any number of times, rushing in to offer my opinion where, the better angels of my nature would suggest that I should fear to tread. So it's one of those things where I don't know the answer to it. I simply don't.
Okay.
And the distinction between personal injury versus a product liability, that seems pretty obvious. But at the same time, that's a kind of thing where, I'll tell you what, we're about to go to break, and then we'll see what we can, I'll see what I can scrape up, just to give you some idea. Now, are you're not the person who had the mesh, are you?
Yes.
Okay.
Males and females.
Yeah. So what did your attorney say? I mean, did you ask the guy who was doing the lawsuit? What did they say?
I haven't asked them. That's a good question, actually.
I mean, they must have been down this road before, I would imagine.
That's a good point. I didn't think to ask them. I was driving down the road. I'm at a location that I've got to actually get off the phone for. So, but I was just curious. I heard, I listened to the station. So
yeah. Well, I appreciate you calling, and I will look into it for you. Like I say, over the news break, if I can come up with something, and I would expect that the attorney handling the claim has been down this road before. I wouldn't be surprised if he hasn't, or she hasn't. I wouldn't be surprised. You got to have kind of low expectations, but let me see if I can. Let me see if I can come up with something that at least would give you something to go to that person with. How about that? Okay. And remember, it's a lively legal discussion, but not legal advice.
Right. Exactly. Yes. Exactly.
Thank you, Peter. Thank you for calling. You have a happy Easter. Okay.
You too. Happy Easter. Bye.
Bye now. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. We'll be back right after the news with Mike, who has a question about capital gains. Always a fascinating topic. Again, I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. Now's the time for you to give us a call, 616-774-2424. That's 616-774-2424. Just a little back of the envelope legal analysis here on whether or not product liability awards, so you got a bad product and it blew up on you, are the proceeds from a product liability lawsuit available in a divorce. And the initial stuff I looked at suggests that it is. In a personal injury, let's say you got hit by a car, the amount of the award for, and which is typically the bulk of it, for lost wages and whatnot, that definitely is marital property, to the extent there's anything definite about this stuff. And but the amount for pain and suffering, that's personal. That would be separate property because you experienced that yourself. So, how would that work out in liability, especially when it's a medical product, and you got to go through all the pain and suffering? Well, if a portion of the award were for your pain and suffering, I think you've got an argument there that it would be separate property. But to the extent that it's compensation, for lost wages, that kind of thing. And there's a whole separate claim in there for what they call loss of consortium, which is the spouse's claim anyway. So you really do need to talk to the attorney who brought the claim, find out what it was, what they call the elements of damage. What are they, and what number do you put for each one of those? So I hope that's helpful. But when you talk to Peter, when you talk to the attorney who's putting the case together for you, that's what you want to say is what are the elements of the damages? Okay, which part is lost wages, which part is pain and suffering, which part is loss of consortium, because they're going to be treated differently. That said, just in a quickie review here, there's all kinds of precedents all over the place. So it's shifting sands is what it is. There's not much definitive about that. Sorry. Well, in the hopes of finding something definitive, we've got Mike on the line. Hello, Mike. Welcome to the David Carrier Show.
Oh, good morning, David. Got a question. I called in a few weeks ago.
Yeah.
With a question on capital gains from inherited property that is in a trust.
Yep.
And you stated that it's either the value of the property at the time of death or the value of the property 6 months after death.
Well, if you sell it in the interim time, so you've got the date of death, you've got the alternative valuation date, and generally, if you sell it in the period, the 180 days between the date of death and the alternative valuation date, then whatever you sell it for, they'll use that as the basis. Yeah, that's the rule.
Well, it's
and now I'm wrong. Days. Oh no! So what did you find out?
Yeah, it's been approximately a year.
Okay.
Anyway, the property's in a trust, and I informed the executor of the trust about this, and she is saying that as long as they have an evaluation from the realtors, that should be valid, and that just does not sound right to me.
Well, if you
does it have to be done by an actual appraisal?
So the IRS got tired of being jerked around with, opinions and stuff like that. And generally, so here's the thing. If you actually sell it, well, at some point there's going to be an appraisal just to get the thing financed. If it's a cash sale, then you wouldn't necessarily have to have an appraisal, and you could go, assuming it's an arm's length transaction, all that. But you guys are hanging on to it. I beg your pardon?
We got a cash offer on 2 vacant lots that we're accepting.
Okay. Well, then the cash offer is pretty good. Basic law is that the fair market value of an item is when you have a willing buyer and a willing seller, without externalities affecting the price. And it sounds like that's what you've got here. Now it's been over a year. So then the question is, what is the value? What was the value back in the day? So if you've got somebody saying, hey, the market's generally gone down, generally gone up, it's not like you can't use that. But if you get audited, then the IRS is going to want to see an appraisal, and like I say, they got jerked around there for a while with the various, and then they did certified appraisers, and there's all that. Now, can you go based on what a realtor tells you? Well, probably. I mean, if they're basing their opinion on comparable sales and all the rest, that's what a certified appraiser is going to do. If when the tax return for the trust, see, the way this works is you sell the thing out of the trust, and then the individuals receive, and if there's no profit, then you can file a trust tax return. Generally speaking, what happens is you sell it, the trust files a tax return, and then each individual trustee gets what's called a K-1, which is, a 1099 that you got on your bank accounts, that kind of thing, that says you earn
Right.
5 cents. Yeah. So a K-1 is like that. A K-1 distributes your share of the profits, of the gain, whatever. And then when you file your tax return, you say, yeah, I got in $10 from the trust, and based on what the trust said, there was no gain as part of that. Okay. And then you just file that with your taxes, and away you go. Now, what the question is if you get audited, what is the validity of saying that the price a year after the date of death was the same price that it would have been a year ago? That's a good question, right? And is the sale now at the same value during the date of death, alternative valuation date? Okay, so at some point, if you really get into it, IRS is going to want to see an appraisal. The good news is that appraisals are based on historical data. I mean, you can actually come up with an appraisal 10 years later that'll still be valid because it's based on comparable sales. And you can do the research and figure out what those that's what an appraiser does, and figure out what those comparable sales would have been or were, and so come to an opinion that way. So it's not all bad that sister's trying to save the trust some money. What's the value of the property anyway, if I could ask?
Got 2 half-acre lots, and the offer is, and we have accepted it, as the heirs of the trust, of $170,000 for both lots.
At 100.
At the time of
Mm-hmm.
Yeah, at the time of death, the lots were valued around $50,000 each. And so they have come up in value really strong. It's in a booming area.
I get the appraisal.
Get an appraisal?
Yeah, if it's a $15,000 property, right? Who cares? But if 2 times the SEV, the state equalized value, the tax value on the property, if you look at the tax statements, and it was 50,000, and now you're selling it for 170,000. Did I catch that? 170. Then I wouldn't monkey with it. It's going to cost a couple $100 at least to get the lots appraised. It is. It's not insignificant, right? It's at least what you're going to spend on Easter brunch today. But it's a peace of mind thing, and like I say, if at 170, if it's lower value, it's $15,000-$20,000, and these are a couple of lots, who cares? And what's the downside? And it's fairly close to the SEV, the state equalized value, the tax value, right? Oh, that music means I need to get out. But I tell you what, we'll be right back with more of the David Carrier Show. And if you want to hang on, Mike, I'll explain why I think you need to get the appraisal. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. I know we've gotten a lot of complaints that we're not playing Motown as we usually do. Sorry, it is Easter and we are live. So you get the Mormon Tabernacle Choir there. I hope you Easter appropriate music. Come on, get with the program, will you please? Anyway, we're talking to Mike about capital gains, and we don't have a real dispute on what the rule is. So here's the idea: when somebody dies, okay, because we can't figure out, and this is where it came from, because we can't figure out what they paid for it. We can't figure out what the decedent, the dead person, paid for a given property, and we're talking. This has been this way over 100 years. We just say, look, we're going to let you start over again on the date of death. Okay. So we can figure out when somebody died. We've got death certificates, right? We've got other records. We can figure out whatever it was, stocks, bonds, mutual funds, because those, anyway, forget about mutual funds, stocks and bonds, right? That you bought, businesses, other assets, real estate. We can figure out what that was worth on the date of death, because number one, we know what the date of death was. And then secondly, there are records we can figure out what this was worth. That's the idea. Now, we can't figure out what it was worth 60 years ago when Grandpa bought the thing, but we can figure out now. And so what we're going to do is we're going to say, you get a do-over. We're going to pretend that the heirs, that the beneficiaries paid for this. Now, obviously, you didn't pay anything. Okay, you didn't pay anything. Got it. You inherited. I understand. But we're going to pretend, IRS is going to pretend that you paid fair market value on the date of death. Now, because stocks in particular tend to wildly fluctuate, up, down, sideways, all the rest of this stuff, then they said, oh, yeah, that's kind of screwy, just the date of death. We're going to let you, we're going to give you the alternative valuation date 180 days later. And if you sell it in the meantime, we're just going to pretend that whatever you sold it for was the fair market value, and you don't owe us any tax. You paid fair market value. You sold it for fair market value, no profit, no capital gain, no tax. That's the idea. Now, what Mike's family, mom or dad died. They left the kids a couple of lots, and they sold them about a year later. Not 180 days, but a year later. Other facts that are interesting to know is that the price of these lots has skyrocketed. So where they were worth around $50,000, they were sold for around 170, something like that. So significant increase, and a significant amount of money as well. That it matters. It matters. And now we're selling them not 180 days later, but a year later. It is unusual for real estate to jump around very much. It doesn't usually do that. Stocks do, yes. Shares, that kind of, that'll jump around. Okay. Jump around, jump up and get down. Yeah. Anyway, we'll put that on the bumper music next week. Anyway, you don't get that kind of fluctuation very much with real estate. Now, the question is, should the trustee rely on a broker price opinion as to what the value was 6 months ago, back during the valuation period, alternative valuation date? And the answer is sometimes. So if the value of the property, it's just gone up incrementally, okay, it just goes up a little bit. It's within the range. It's very close to what the state equalized value is, the tax assessed value, right? Then, and you've got the real estate broker, realtor is telling you, hey, here's what I priced it at because I got all these comps, and you're not talking about that much money. Then you say, well, yeah, okay, fine, because the risk is very low. Okay, you're evaluating risk here. What's the odds I'm going to get audited? If I do get audited, can I back up my position, which is the key, right? So, and then what's the consequence? What if we're wrong? I mean, how much money are we talking about? Not much. Okay. Well, that's one way to look at it, right? Well, then I don't really need an appraisal. Need. So, but now we're talking 175,000. Mike has told us that the property has increased in value rapidly. It used to be worth around 50. Now it's worth at least 3.5 times as much. Well, those are all things that make you say, perhaps it would be worth investing less than $1,000, a few $100s, couple $100, whatever it is, in getting a vacant land appraisal to back up the valuation as of the alternative valuation date. Because if the prices have been going up, we don't want the date of death value. We want the alternative valuation date. So let's get it as of that date. And if the appraiser, and then let the chips fall where they may, if the appraiser says, hey, these lots were selling 180 days ago, 180 days after the date of death, these lots were selling for, $100,000. And now whoever announced the project, and now it's gone up. Okay, well, that could be. And then you just pay your capital gains on the difference. But at 175,000, in a market where the value has gone up rapidly, spend the money. Spend the money. Just get it done. Let Mike sleep at night. That's what I think. So, it's one of those. I guess it's one of those things. Where you look at a situation and is there a book answer to it? Yeah, get an appraisal. That's the book answer. But you don't always go with the book answer. If you got a certified appraisal, do you have anything to? No, you don't. But there are factors involved, right? When you think about it, well, okay, how reliable is the price data that I already have? The SEV, the state equalized value, right? The tax value. How far away are we from the alternative valuation date? Well, it's 180 days. It's been about a year. I get the first 6 months, so it's only about 6 months of appreciation. But on the other hand, in this market, in this particular situation, and that's the other thing. Oh, music. The values can go up rapidly and anomalously, in ways that you don't expect. And I think that's what's going on here. I get the appraisal. Let's spend the money. It's 175,000. Why not relax? Why not worry about it? That's what I would say. You've been listening to the David. See, you don't want a nasty surprise from an Easter egg. Yeah, you don't want one of those. And I think that's what you might get if you don't get the appraisal done. That's my lively legal discussion, but not legal advice. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Hello and welcome to the David Carrier Show. I'm David Carrier, your family's personal attorney. And yeah, I know it's Easter, Resurrection Sunday. The voice of God there. Anyway, now's the time to give us a call, 616-774-2424, area code 616-774-2424. As always, live and local. Not just local either. If you get the app or, want to download it or go online, or there's ways to do that. Drop me an email, david@davidcarrierlaw.com. In case you want to find out how to do that, we can hook you up. How about that? And of course, if you're on the newsletter list, if you want to get on our newsletter list, that's fine, because we actually record these. Not only are they available on iTunes and on the iHeartMedia website, but we'll send you the clips if you want, with my smiling face, and I can prove that I have a face made for radio in those, because those are actually like Zoom meeting kind of thing. Anyway, Lots of ways to interact if that's what what you have a mind to do. But this is the place where we talk about estate planning, elder law, real estate, and business law. So give us a call. It's easy to do. One of the things that it's an absolute train wreck that's coming to a state near you, the state of Michigan, and it's not only us, it's everywhere. And this is what I was. If you've been listening since the first segment and wondering when's he going to get back to that, I'm getting back to that now. The way long-term care works is people go broke, they go on Medicaid. That's what happens. Only about 25%, thereabouts, of long-term care costs are covered by individuals. They quickly go broke, and then they go on the 75%, which is government money. Government meaning taxpayer money, meaning look in the mirror, it's you. Okay, you're paying for this. Anyway, the way it works is on the Medicaid is every year they check up on you. So you apply, you get the benefits, which is no easy process. I make it sound like it's easy, but it's no easy process. But if you do it and you get the benefits, once a year you have to report. It's called redetermination. All right. So they already determined you were eligible. Now they're going to redetermine on an annual basis. Now, if you ever try to get your kids to make their bed or do whatever, you got to check up on them, right? You know this. You need to be checked up on. Let's admit. This is why we have bathroom scales, so we can step on them and check up on ourselves and weep. Anyway, on an annual basis, Medicaid checks to make sure that you're sticking to the straight and narrow as far as the financial qualifications go. Okay. So if you have a loved one in long-term care, the chances are 80% anyway that they're already on Medicaid or will be shortly, because that's how it gets paid for. Now, once a year, they double check to make sure that you didn't go over assets. It's possible to do that. Not that hard. It's easy to screw this up. And many people do manage to screw it up in 12 months. So you get a year, go up for redetermination. And remember, we've done literally thousands of Medicaid applications over the years. I mean, this is not, gee, I wonder what happens. This is, I'm reporting from the front lines here. Anyway, with the COVID, they said, that's too hard. We're not going to do that for a while. They wound up not doing it for about 40 months, over 3 years. They didn't check up. They didn't do the redeterminations. And as a policy matter, and there were so many federal dollars, it was okay, I guess. They had people they knew were not eligible for the Medicaid benefits, and they gave them out anyway. They paid them anyway. That was COVID. You remember that? The the unspecified virus of unknown origin. All right, you remember that. And so that was the way it went. Now, sooner or later, you ever play musical chairs? You know what musical chairs? It's like the game where there's one less chair than there are people playing, and every time the music stops, everybody got to sit down. Except one person sits on the floor. That's the funny part of it. And pretty soon there's only one winner because they keep taking away the chairs. Well, they finally taken away all the chairs or something like that. And the music is about to stop on the forbearance that Medicaid has had on this annual update thing. It's over. Okay. Starting June 1st, Center for Medicare and Medicaid Studies said, okay. And listen, they've been warning that they're going to do this for a long time. And they finally said, okay, it's going to be June 1st. That's when we're going to start with these redeterminations. Now, if people mess things up after 12 months, right? They've got too much assets here, and they did something wrong there, or they didn't pay the patient pay amount, or something went wrong. Okay. And in 12 months, it went wrong. Can you imagine what people have done over 40 months, right? For those of you playing at home, that's 3 times as long, right? 36 months, 3 times as long. And so, and there's a whole bunch of people who are receiving benefits who everyone expects are going to get bounced anyway, bounced off the system. Why? Oh, this is so harsh. You said bounced. Yeah, too bad. Get over it. They're going to lose benefits. Okay. This will be a very bad thing. Very bad thing for who? Well, if you're a long-term care facility and you've got people on there on Medicaid, and most of the people in a long-term care facility are on the Medicaid. That's just reality. Okay, that is the way it is. At $12,000 to $15,000 a month, I saved for my, this is the little thing I love. Oh, I saved for long-term care. I'm not interested in that Medicaid stuff. I saved for long-term care. Really? At $12,000 a month, you saved. How much did you save? All right. According to the federal government, National Institute of Health, longtermcare.gov. Don't believe me. Go to the website. You can see it for yourself. On average, people need 3 years of skilled care. Now, that's not all nursing home care. I'm not saying it is, but a significant amount of it is. This is how people go broke. This is how middle class goes broke. Okay. And now we've had 3 years, 40 months, 3.5 years of, there's no guardian at the gate. There's been no accountability. What do you think is going to happen? You think they're going to just say, oh, well, don't worry about it? They can't. They don't have the money anymore. The COVID money dried up. It got spent. It's over. What now? See, this is what we're confronting come June 1st. All right, when redeterminations start over again. So what we've done the outreach to our folks, the 100 or so folks we've got on the Medicaid right now, to say, hey, we better get your house in order because it's going to matter. It hasn't mattered for the last 3 years. It's going to matter. At some point it matters. And now's the time to start putting your house in order. So if you have a loved one in long-term care, right, where you're receiving the Medicaid benefits, you really need to take a hard look at it. You really need to go through. Now, we're offering at the firm, here's the, crass commercial, my crass commercial interest here, right? So for our clients, and we've already sent this out, we'll review it for $1,000. If you're not an existing client, it's $1,500. There's a lot of work that needs to be done. You say, "Whoa, $1,500, that's a lot of money." Say, yeah, it's a lot of money. So it's $15,000. So if you want to lose benefits, I guess that's okay. But I don't recommend it. Because here's the other thing. Everyone thinks the house is protected. If the nursing home isn't getting paid by Medicaid, nursing home is not getting paid by Medicaid because they finally did redeterminations, right? And you didn't meet the criteria. What do you think they're going for next? And by they, I mean the nursing. I don't mean the state of Michigan. State of Michigan don't care. Nursing home's not getting paid. And that protected house with the ladybird deed that you did that sounded so smart. Oh, it's so wonderful. Worked for everybody. Goodbye. Kiss the house goodbye. Because that's the next step. Now you get sued. The only asset left is the house, whatever. And that's the way it goes. That's what's coming June 1st. And that's just reality. So if you have a question about that, if you're thinking, hey, you got a screw loose there, fine. Give me a call. 616-774-2424. That's 616-774-2424. The music is going to stop. If you want to be the one sitting on your keister, hey, it's up to you. In the meantime, there are things you can do about it. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. And this is, we are live. I know it's Easter, but we are live. So, I know you're going to be hanging out with the Easter Bunny and collecting them colored eggs and all the rest of that stuff, which I'm not opposed to that. I don't want to get the idea that I'm all opposed to that. I'm not. But it's like Christmas. You know what I mean? The reason for the season and keep Christ in Christmas and all that kind of stuff. Yeah, it's wonderful. Holly berries and the weather outside is frightful and all the rest of that. I'm not opposed to it. But I am opposed to substituting the trappings for the underlying reality, I guess, for the underlying meaning, purpose, intentionality, whatever you want to say. And it's like, and I get it. Look, if there's people who don't, you don't believe in it, you know what I mean? You're here for the Cadbury eggs. Well, okay, I'm not opposed. That's fine. But I think sometimes we get distracted by the flash, by the it's the old Charlie Brown Christmas special, right? The Peanuts Christmas special. It's like, what is Christmas all about? And then Linus explains it, and the Christmas trees and the Easter eggs and all the rest of that stuff. That's all great stuff. I'm not opposed to it, as I keep repeating. And I'm not opposed with people having everybody over for brunch and the ham and my mom was a big. Well, seriously, I mean, she did the cloves in the ham. Do you remember that, when you put cloves in the ham and then put she festooned the thing with chunks of pineapple and cherries. You know what I mean? Those maraschino cherries. And, it made for a very much a good housekeeping sort of presentation there with the, and as I recall, it was actually pretty good. But do you remember that, with cloves in the ham? And then nowadays, of course, we go for a honey baked ham, and it's falls off the bone, and it's so easy. I'll stick with the cloves. Anyway, confusion of means and ends and what's really going on and all the rest of that. I think you see a lot of that. And nowadays, no exception. There's a lot of times we get distracted by superficiality, by the surface of things, and don't go to the reality. And I think that's part of the human condition. And I think part of what we have to do, and it's a struggle because it is part of the human condition. It's a struggle to focus on what's really going on here, what's really important. And the people who are selling the chocolate Easter bunnies and stuff want you to think it's all about buying chocolate Easter bunnies and going to brunch. That's what they want you to think. Sadly, many people do think that. Maybe people do think that that's what it's really all about. Same way with the estate planning. Were you wondering how I was going to tie this up? Anyway, it's the same way with the estate planning, right? It's like, oh, you need to trust. You need to trust. Not why do you need to trust? Not what are you trying to accomplish? You just know you need it. And now you check the box, and now you can move on. There's a lot more going on than that, I think. And well, you decide. You always get to decide. So let's get back to it. We got an email here, and this is a situation that happens. That's why we picked this one frequently, put it that way. And most of the time it's dealt with poorly. It's dealt with the way they're suggesting here. Okay. So let me get at it. Is it possible to refuse an inheritance to preserve Medicaid benefits if the death occurred more than 9 months ago? My father passed away in October 2021 without leaving a will. $500,000 estate, still in probate. I'm executor, legal guardian for developmentally disabled, they say developmentally delayed, but developmentally disabled sister. Because there's no will, my 3 sisters and I each inherit 25%. Okay, that's $125,000. For those of you who are math challenged, right? 4 goes into $500,000, 500,000, 125. So let's see. All my sisters are disabled. But I'm mostly concerned with my developmentally disabled sister who receives Medicare and Medicaid benefits. Question why the other ones aren't receiving similar benefits, whether it's SSDI, SSI, or whatever. That'd be a question. Can I, as her legal guardian, that's why we're a little more concerned about this one, refuse the inheritance on her behalf in order to protect her Medicaid eligibility? I asked my attorney this question many months ago and was told no. Now I read it could have been done within 9 months of Dad's death. Do I have any recourse now? Well, this is the problem that you get into when, number one, you ask the wrong kind of lawyer the question. That's a problem. All right. He asked the lawyer, and probate lawyer, I'm guessing, the one who's doing Dad's estate. And then he said, no, you can't do that, which is wrong. There's a way to do it. There's a way to do most anything. And we'll talk about that. But then also now now he's done some research, right? And what he's read is that in order to have a qualified disclaimer under the Internal Revenue Code, that disclaimer has to be made within 9 months. If you fail to make the disclaimer, or if you receive any benefit from it, even if it's 2 months later, but you receive benefits, then you can't make a disclaimer. That's a tax law issue, okay? See, everybody thinks, oh, the law is the law. The law is not the law. There's tax law, there's probate law, there's Medicaid law, there's estate planning law, there's law all over the place, okay? It's like, now the springtime is coming. It's like weeds in your garden. Before you know it, it's all over the place. And they're not all the same. Some are dandelion, some are chickweed. There's creeping kudzu in some places in the country, I guess. Anyway, there's all kinds of weeds out there. There's all kinds of law out there. And not what works on one doesn't work on the other. So what you've got there is the tax law, which says that you have 9 months to make what they call a qualified disclaimer. If you're entitled to receive something, you can say, I don't want it. Now, there are some things that you cannot say, I do not want. For example, you cannot disclaim an IRA inheritance if you're in bankruptcy. Otherwise, you can. All right. But if you've got creditors out there, you can't say, I don't want it. Or if you're in bankruptcy, for example, you can't say, I don't want it. Same way with Medicaid. Now, under the 9 months that you're talking about has to do with a qualified disclaimer under the tax law. So let's say your sister was a very high income person paying 40% income tax, and you didn't have to pay any income tax at all because you were so low on the income scale. Well, your sister might very well have said, Jeepers, brother, I'm going to disclaim. I'm going to say, I don't want my inheritance because and this wouldn't work either because it's not income, it's an asset, but roll with me on this one, okay? There might be a tax reason. There might be a tax reason why sister would say, I don't want it. She didn't want the income from it or what, because it wouldn't be income itself. But or with an IRA, it would be income. Okay. So it might be income. Anyway, she says, I don't want it. You can have it. Pay tax at the lower rate. You could that would be a reason for a disclaimer, okay? For example. But that doesn't work for Medicaid. For Medicaid, you have to take, you have to account for what you already own, and you cannot refuse to accept income. You cannot refuse to accept an asset. If you do, it's the same as if you gave it away. And you say, well, how are they going to catch me? That's a different issue. Catch me if you can, right? Well, on Easter Sunday, let's not be worried about how you get away with criminal activity. Okay, let's be a little more concerned about here's how you comply and still get the benefits. And that's what we're going to talk about when we get back. Because this is not a over and done situation. The assets are still held in the estate. Good. Because we haven't distributed them yet, we don't have to file the change report with Medicaid just yet. Good. But sooner or later, those assets have to come out. They have to come out of the estate. They have to get distributed. Disabled sisters, plural, cannot say we don't want them if they're on the Medicaid, because now you'll disqualify them from the Medicaid. They can disclaim, but that will be treated as a divestment. Very bad. When we get back, we'll tell you what needs to be done here. In a lively legal discussion, which is not legal advice. I'm still David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. Now's the time to give us a call if you'd like. I can't force you anyway. 616-774-2424. That's area code 616-774-2424. And you can't kid me. I know it ain't long distance. There's no more long distance. So you can call, We did have that, for years. I don't know, we've been at this for what? Going on 20 years, something like that. It's been a long time. Yeah, if you think it's been a long time, you are correct. It's been a long time. But, we did the 888-GO-DAVID number. You remember that? But it's like hard to remember. And this is the number that gets you to the studio. So there you go. 616-774-2424. Not that it matters. Now, is it possible, getting back to our email here, is it possible to refuse an inheritance to preserve Medicaid benefits if the death occurred more than 9 months ago? And this is a typical mulligatawny stew that people make when they look at one area of the law and they say, oh, it says here I can disclaim an interest if I do it within 9 months. The lawyer must have screwed up by telling me I couldn't do it. And that has to do with a disclaimer of a property interest for tax purposes. That's what the IRS says. You can disclaim within 9 months, right? If provided you didn't receive any benefit from it. Now, the lawyer still screwed up, okay, but that wasn't how they screwed up. But you see, you asked him a specific question. You said, can I disclaim it? And the attorney said no. Can I refuse the inheritance on her behalf to protect Medicaid eligibility? And as guardian, it's your job to maximize assets for your ward. Okay. So saying, no, I don't want money, that goes against what you're supposed to be doing as guardian conservator, right? You can't say no, or you shouldn't say no unless there's a good reason. So that's a problem. And so the lawyer wasn't, I say he screwed up, but he wasn't wrong in saying that a guardian can't disclaim benefits like that without court permission. And then how are you going to get court permission when you've got no plan B? It's just because if sister disclaims, now we're taking her $125,000 and splitting it among your other disabled sisters and yourself. All right, how does that benefit sister? You say, oh, it preserves Medicaid benefits. And tell it to the Marines. Nobody believes that. What if you could maintain eligibility and accept the inheritance? This is why I say the attorney screwed up, because he was obviously not aware of what we call a D4A trust. Okay, it's under the Social Security Act. And what it does is if we have someone who's receiving Medicaid benefits, and you have to be younger to do this. I think it's 55, I think is the cutoff. I have to double check. I think it's 55. Anyway, so we've got someone who's developmentally disabled and now receives an inheritance. This particular situation, it's also worse in other contexts, but that's the most common. This is the most common. And frequently what parents will do is they will disinherit the disabled child, which is a god-awful thing to do, because it's not like you didn't care for the disabled child. You did. You wanted to benefit them. And then what they do, get this, then what they do is they double up the inheritance on one of the kids who promptly gets divorced and loses all the money, or goes bankrupt and loses all the money, or just decides it should be their money. And now the disabled child has lost all the money, right? That's what happens. It doesn't always happen. It didn't happen here. Yeah, I know. So why don't you go around with your seatbelt unbuckled and hope you never go through the windshield? That's not what we would. What was that? In the Avengers, not a good plan. Yeah, it's not a good plan. It's not a plan. It's just hoping you'll get away with something. Are you kidding me? So here's what you do. Especially you're already in probate. You're already the guardian. Okay. You do this thing called a D4A trust. Now, the key to this trust, it's what they call a Medicaid payback trust. And the idea is I'm going to take this $125,000 and I'm going to put it in this trust. And I can spend it. You can spend it, right? This is what we ask for. We ask the court to do. You can spend it on sister's benefit for sister's benefit over her lifetime. See how much better this is? Instead of taking her inheritance and splitting it 3 ways among the 3 of you, and you do whatever you feel like with it. Because here's the other thing. Because what if sister said in the disclaimer, which you can't do, okay, you can't direct where it goes. All you can say is, I don't want it. You see? And you might be thinking, well, if I did a disclaimer, she could disclaim it to me. That's not a disclaimer. Okay? It doesn't work like that. If she directs it, if the developmentally disabled sister directs who gets it, then it's just the same as if she had it. Even under the Internal Revenue Code, it's the same. Even for tax purposes, it's the same. So she just has to say, I don't want it, which means that because dad did not leave a will, that's what it says, dad did not leave a will, which he should have. All right. Again, bad advice or something. He's got $500,000. He doesn't have enough money to set this up so that you don't have to spend the long dollar now. You spend a little bit of preparation. Well, what was that? What's that saying? Ounce of prevention, pound of cure, all that. Stitch in time saves 9. There's things like that. The reason they're aphorisms, cliches, or proverbial wisdom is because they're wise. That's why. If this had been set up properly, none of this would have been an issue. But it wasn't set up properly, so now it is an issue. So what brother here has to do I have any recourse now? Yes. What you do is you go to probate court and you say, hey, judge, I want to set up a trust, a D4A trust, right, for the benefit of my sister. And I promise, and one of the things you have to promise, I'll report to you whenever you tell me to, right? And most it's a non-reporting thing, but okay, you can report it. As part of the annual report of the guardian, you can do that and say, hey, I got this D4A trust out there. Here's the money I spent on sister. Here's what's left, blah, blah, blah. Okay, fine. There's accountability. And now you've got $125,000 that you can use to, to enrich sister's life. Are you with me on this? She still gets her Medicaid benefits. She still gets her Medicare benefits. Dual eligible. She still gets those. And she's got the extra money that dad set up for her, that dad left to her. Now, if dad had set it up, it wouldn't cost the big bucks now. Oh, please, judge, do this. And you're hoping that the judge will do it. And here's the well, when we get back, I'll tell you about different judges, but because they are different. But here's the idea. I'm not throwing the money away. Do you see? Now, part of the deal with a D4A trust, a Medicaid payback trust, is that when sister dies, any leftover money goes back to pay back the Medicaid. That's what we call it, a Medicaid payback trust. It's not the only way to do it. Are you surprised by that? Good, you're not. You've been listening. So it's not the only way to do it. There is another way where you don't pay anything back to the government, but you still have to pay it back to somebody. So we'll get into that in the next segment. But this is not at all an unusual situation, and most of what you see is all screwed up. Here's how to fix it. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. It is Resurrection Sunday. Happy Easter. And don't eat too many of them Cadbury eggs. Oh, my God. Anyway, you can call us and we get 5 minutes left, 10 minutes left. Hopefully we'll knock this one out. This is a situation where we've got developmentally disabled sister. Our letter writer, our email writer is the guardian for sister. So they're already in probate court. Dad did not do any planning. He died with $500,000, meaning each kid gets $125,000. There's 3 sisters and a brother. All 3 sisters are disabled. No explanation for that. But one developmentally disabled. And so, okay, we're worried about that one in particular. But this advice applies to all 3, because if you are on disability, chances are good that you're receiving other benefits that are what they call means tested. In other words, it matters how much you've got. If you don't, well, don't worry about it. Just take the money. But if you have benefits that are means tested, this is what you do. The deal is you have to go to probate court to do this. Now, Dad could have done this. Dad could have done this himself and wouldn't have had any payback on it. It could have gone to the other kids, but he didn't do that. And so now we've got to go to probate court. And we got to say, hey, Judgy Wudgy, I want to set this thing up, and I want this money to be available to sister. And then when sister dies, then any leftover money goes back to the government to pay back for her Medicaid. But I don't want to lose benefits, take her off the Medicaid until the money's all gone. And then, right, and then later on, try to get her back on the Medicaid. That would be terrible. Plus, she would get 0 benefit, right, 0 incremental benefit, additional benefit from the inheritance. And the law says, well, that's okay. You can do that if the judge says okay. Now, some judges will go by the statute. So you've got federal law that says this is what needs to be in a D4A trust, and they'll go with that. You've got, and there's D4A, B, and C trust. Okay, there's different trusts. So we're not going to get into that here. Anyway, but I should note that, because next thing you know, I'm going to get an email. Well, you didn't talk about the D4C trust. How about that? Okay, I know what's out there. Anyway, point being, some judges, when I'm intimately familiar with, they even have, get this, the first one I did there, which was at least 12 years ago, instead of accepting the trust that all the other judges had in different counties had accepted, this judge says, well, I want this additional reporting and that additional reporting and a laundry list of things, marked up my, took a pen and ink, right, and wrote all over my trust and added a bunch of stuff and then issued it as an order. Okay, so fine, I got what I wanted, because it was a developmentally disabled situation, developmentally disabled person, and this money would have knocked her off a program she'd been attending for the last 20 years. And anyway, this is the remedy. This is what you do. You do one of these trusts, and now the money is available to support. She needs a TV set. She needs more clothes. She needs something. And frankly, if you're on the correct benefits, it's pretty hard to find out what that extra something is, unless it's travel or something like that. But then the money's available. I haven't wasted the money. I haven't given it to somebody else. It can be targeted directly to the person who's receiving these benefits, and the benefits continue, and they get the additional incremental value that the parent wanted them to get. So it's a very good thing. Now, if you had planned ahead, you wouldn't have to worry about probate court. You just plan ahead and do it that way, and you set it up so that the beneficiary does not have such control over the assets that would disqualify him from the Medicaid. There's a way to do that. And, if it's parents, then that's what you do. If it's spouses, there's another process. Anyway, that's one thing. Here's the other thing. And for those of you, running a nonprofit or a church, churches can do this. There's what's called a pooled income fund. Now, here's the idea with the pooled income fund. The Medicaid Payback Trust pays back the government for the Medicaid, okay? But it's different with a pooled income fund. With a pooled income fund, your nonprofit sets it up, okay? You have a nonprofit, sets it up. And inheritances like this one, $125,000, go into the pot. So we get inheritances from all these various people who are on the Medicaid, who got an inheritance, a lump sum of money for some reason, and we don't want to lose our Medicaid benefits. But we don't want to give it back to the government either. And so what you do is you put it into this trust. We pool it. It's a pool of money. And now the money is available, right? And each one has their own account, so you know how much each one kicked in. But now you have economies of scale, because we've got all the money managed by one money manager. So that's good, right? And you've got a trustee who will spend the money for family members' travel to come see you, for a private room instead of a semi-private room, for clothing or whatever it is that may be of benefit to the individual. The key to the pooled income fund, though, is that rather than having to get each one approved on a separate basis, right? Because we've got economies of scale here, and then the money goes to the nonprofit. See, rather than going to pay back Medicaid, the nonprofit keeps the money, right? So you've done two good things. Number one, you made sure that the inheritance, whatever it was used for the benefit of your family member. Now, you can't, if you haven't planned ahead, you can't give it to the other family members. It's over with, okay? When the disabled person dies, you can't give it to the other family members. And you can't disclaim it either. We already covered that. But you may say, well, I would rather it go to the, Alzheimer's Association. I'd rather go to Meals on Wheels. I'd rather go to, Kidney Foundation or St. Jude's Hospital or somebody like this. You may want that rather than have it go to government. And that's what the pooled income fund is all about. Okay. You put the money in it. The trustee spends it. Now you have to give up control. Yeah, you do. But it's better than giving up your benefits. Right. And these people, the trustees of the trust, they understand that the money is your money and it's being used for your benefit. Not legally, technically, it's not your money anymore because you put it in the pooled fund. But the idea is that it's for your welfare, for your benefit. Okay. So in a situation like we're confronted with here, what does the guardian do? I would set up the D4A trust. I mean, that's what I would do. But you might have a charity that you're nonprofit that you are intimately connected with. Maybe it's the type of developmental disability. Who knows? And you might say, well, I'd rather throw it in there, right? And not worry about spending all the money before I die. And instead, it would go for the benefit of this organization whose goals I support. So you see, you have options. And what the attorney told this guy, which was you can't disclaim, that wasn't wrong, but it certainly wasn't the whole story. The rest of the story is the money can be used for the sister's benefit and then, for the benefit of the whatever. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney, wishing you a happy Easter.